Hello and welcome to everybody. It's taking us a little while to get everybody in because this is an incredibly popular seminar. I can say only on the back of last year's successful event where we promised to make it COVID-free. We're going to try and live up to that again, although I think we might sneak in a few comments towards the end, given the news of yesterday. Look, welcome. I'm Kevin Poulter. I'm a partner in the employment team here at Freet. I'm joined by my colleagues, Tom Draper, Lee Ashwood and Shraddha Virji, we're going to sort of hopefully give you some interesting comments, things that you may have missed over the past 12 months, and some things to look out for in the coming year as we step into incredibly 2022. So without further ado, because we've got a hell of a lot to get through, I'm going to hand over immediately to Tom Draper, who's going to pick up with, the first of the few key employment law developments from the past year. Thanks, Tom.
Great, thank you very much, Kevin. So I thought I would start by talking about employment status because we've had two big cases on employment status over the last 12 months. The biggest being the Uber and Aslam case in the Supreme Court. And I'm also going to talk about Stewart Delivery and Augustine, which was a Court of Appeal case. So you'd probably be aware that there's been a bit of a battleground between workers and employees on the one side and employers on the other side in respect of employment status, particularly in relation to the gig economy. So the gig economy is going rapidly over the last 10 years or so, and it's been accelerated further as a result of the pandemic. It's the ability to use technology, particularly apps, to allow access to gigs for individuals to do, which has allowed this rapid growth in the gig economy to develop. So for many businesses, this has been a lifeline so that they can respond to fluctuating changes in demand. But on the flip side of the coin, some of the people working in the gig economy, particularly Uber drivers or people delivering Amazon parcels and moped couriers in the case of Stewart Delivery, feel like they aren't genuinely self-employed, and in fact they are either workers or employees by virtue of the way that they are controlled by their employer. So why does employment status matter? Well, just as a recap, there are three types of employment status. You can either be an employee, self-employed contractor, or a worker. And the reason why your employment status is important is because employees have the highest level of protection. They have protection from unfair dismissal, for example, and they also have a right to claim a redundancy payment, whereas self-employed contractors have virtually no rights. And sitting in between the two, there is this intermediate category of a worker who have some of the rights of an employee, but not all of them. The important rights, where particularly in the gig economy, the battleground has focused on, are the rights to the national minimum wage and also the right to paid annual leave. So these two types of rights are rights that workers have, but self-employed contractors don't. And so both these cases that I'm going to look at involved people working in the gig economy who said, well, I'm not a self-employed contractor, as you say, and I am in fact either a worker or an employee. And by virtue of being a worker, I should have been paid backdated holiday pay, and I should also have been paid the national minimum wage. So how does an employment tribunal determine someone's employment status? Well, first of all, they have a look at the level of control that the individual is under as a result of the work that they do. They also look at whether there is an obligation on that person to do that work personally themselves. And then they also have a look at whether there's something called mutuality of obligation. So that's a bit of a mouthful, but effectively what that means is there a requirement for the employer to provide the individual with work to do? And is there a requirement for that individual to do that work? And finally, the tribunal will also look at other factors such as the integration of the individual into the business, whether they're in business on their own account. So to be a worker, there needs to be sufficient control and there needs to be sufficient personal service. So we're going to focus on control and personal service when we're looking at these cases. So firstly, the Uber case. This came out in February of this year, and it was regarded as a landmark judgment because this is the first time the Supreme Court, the highest court in the land, has had the chance to have a look at some of these employment status issues in respect of the gig economy. And the court found that Uber drivers are in fact workers rather than self-employed contractors, as Uber would like to have the court to have found. So the court focused on the level of control that Uber had over their drivers. Firstly, Uber set the fare and the service fee for the access to their app. They also drew up the contractual terms, were non-negotiable. And once the drivers were logged into the app, their activity levels were monitored. So if they turned down too many trips, then they would be subject to a penalty. And Uber also monitored the passenger ratings given to the drivers. And again, the contractual arrangement between the parties could be terminated if the drivers didn't have satisfactory ratings. And the Supreme Court put all of this together and said, well, we think that is a sufficient level of control for us to find that these drivers aren't in business on their own account. They are in fact controlled by Uber to such a sufficient degree for us to find that they're workers. And obviously that then meant that they were entitled to the national minimum wage and paid annual leave. And that meant that the Uber drivers could go to an employment tribunal and claim backdated paid annual leave for up to 2 years. They also get rights not to be discriminated against and protection from suffering a detriment if they made a whistleblowing disclosure. There is also a right for workers to be entitled to a statement of a particular setting out their engagement. And finally, they could also be entitled to, in some cases, a pension under the auto-enrollment scheme of 3%. So a significant cost for Uber, and other similar gig economy employers were looking at this decision and thinking, well, our whole model of business is based on all these people being self-employed. And if we're going to face multiple employment tribunal claims, that could be a very significant cost indeed. So that was the Uber case. The other interesting point that the Supreme Court made was that the contract between Uber and the drivers was disregarded. Previously, that had been the starting point for tribunals. But here, Uber had got their clever lawyers to draft up something that made it clear that the drivers were self-employed, when in fact the reality of the situation was that they were workers. And the court pointed out that you can't contract out of any of these rights for national minimum wage and paid annual leave, which is what Uber had tried to do. So the court was capable of just disregarding the contract. So you can't, unfortunately, if you're operating in this industry, get your lawyers to draft a contract that on the face of it says one thing, but in reality, the relationship on the ground is very different. So that was another important conclusion. So where does this take us if you're an employer operating in the gig economy? Well, it's a good idea to review your contracts and make sure that they still reflect the reality of the situation on the ground. Audit your business, work out who you've got working for you who is potentially self-employed, have a look at the relationship in practice. What is the level of control? What is the level of personal service? And could it be possible that these people have developed into workers or even employees over time? And put measures in place to make sure that they are actually self-employed. And you might need to amend that relationship again to make it clear that they are engaged on a self-employed basis. It also, if you think you are at risk, and I know that some of our clients have done this, they put aside a contingency fund. If they know that people are going to make these types of claims, it's worth having a fund there to be able to settle the cases, because you don't necessarily want to get into a position that Uber have got into, where there's been a clear precedent set for other Uber drivers to point at and say, well, actually, we think we're workers as well. So let's have a look at the next case then, the Stewart delivery case in Augustine. So instead of looking at the element of control, this was a Court of Appeal case that looked at personal service. So here we had a moped driver called Mr. Augustine, who worked for delivery. And again, it's a technology platform, effectively a mobile app that couriers could log on to say, I'm going to do some work in this time slot, and Stewart Delivery guaranteed at least £9 an hour for any time that the employee worked in a particular slot. But it was possible for the couriers to put the slot up for other couriers to take if they didn't want to work a particular slot. And the question then became for the Court of Appeal in this case is, well, does that mean that there was sufficient personal service for that courier to do the work? Or could they substitute themselves for one of the other couriers? And the Court of Appeal followed the direction of travel of many of the other recent gig economy cases and said, well, actually, we think that Mr. Augustine was a worker, and we don't think that there was sufficient ability to substitute himself for anybody else, because there was no guarantee that any of the other couriers would have taken the slot if he didn't want it. And so it was clear to the Court of Appeal that that wasn't the kind of unfettered right to provide a substitute that meant that the service wasn't required to be done personally by Mr. Augustine. So again, this builds on the Pimlico Plumbers case, which was back in 2017, and the Pimlico Plumbers case looked in detail at personal service. And just as a recap, what that said was that an unfettered right to provide a substitute is inconsistent with undertaking to provide services personally, but a conditional right to provide a substitute may or may not be inconsistent with personal service, and it will depend on the degree to which that right is limited and to the degree to which it was actually actioned in practice. And thirdly, a right to substitute only when the contractor is unable to carry out the work is again consistent with personal service, but a right to substitution limited only by the need to show that the substitute was qualified as qualified as the contractor to do the work is inconsistent with personal service. And finally, a right to substitute only with the consent of another person who was an absolute and unqualified discretion to withhold consent is consistent with personal performance. And that's kind of what we had here with the Stewart delivery case. There was no guarantee that any individual courier could substitute themselves for anybody else, which meant that the right wasn't unfettered. So where does this all leave us in terms of personal service? Well, I think it's going to be pretty rare in practice for a worker in the gig economy to say, well, actually, my mate's going to do my job for me today, and for the business that engages them to think, well, yes, okay, that's fine, that's a completely unfettered right, because the way that most businesses in the gig economy work is that they will have some control over the standards of the services that are being offered, whether it's a brand or a uniform or various eligibility requirements for the moped drivers and the way that they perform that work. And so I think it's going to be pretty rare that you're going to find a genuinely unfettered enough right to provide a substitute that's going to meet the requirements set out in Pimlico Plumbers and Augustine. So it's just another example of the courts really giving an indication that they don't like the way that a lot of these gig economy businesses are operating, and they are willing to find that people are workers or employees. So let's have a look at the next slide then, shall we? And this is a case around TUPE, and this is a very important case because it's a big departure from the existing law. So as a recap, the transfer of employment protection, the transfer of undertakings protection employment regulations, TUPE, exists to protect employee rights either on the sale of a business or the transfer of a contract. So either when a contract is outsourced, when it's brought back in-house, or when it's retendered to another contractor. If there's an organised grouping of employees providing fundamentally the same services after the transfer, then TUPE will apply to this situation. The effect that TUPE will have is that the employees will transfer across to the new contractor with their rights and continuity of employment and terms and conditions of employment intact. And the current approach has been that where a contract has been retendered to multiple contractors, then employees who are assigned to organised groupings have gone to the contractor taking on the largest part of the new contract, whereas following a European case, this particular case has actually changed the law now, so that where there's a relevant transfer to multiple different transferees, a contract of employment can actually be split between the different contractors coming in to run the contract after the retender. So different employees can work on a part-time basis for 2 or more employers after a service provision change. So that's quite significant because there was also, it's significant because when incoming contractors are tendering for new contracts, it's not uncommon for the contractor to split that contract up and do what North Lanarkshire Council did in the McAteer case here, and say, well, actually, we've got a contract that's for the restoration of kitchens in our council houses, and we're going to divide that contract into North Lanarkshire and South Lanarkshire. And we, instead of having one contractor do all of it, we're going to get 2 different contractors to do the 2 different halves. And so in this particular situation, Amy was the transferor or the existing contractor, and then McAteer and Mighty were the 2 contractors who came in and took over the contract. And the way that Amy divided the employees up was to give half the employees to one and half the employees to the other. But actually what, following this case, they should have done is work out which geographical region the different employees worked in and assign them on that basis, rather than deciding the amount of time that the employees worked on the different contracts. And so the reason why this is then significant, and what the main takeaways should be for us looking at this is to first of all review the existing arrangements. So if you've got a contract, work out what the exit provisions are in that contract, and work out whether those exit provisions can take into account the possibility of employees being split across different incoming contractors. Have a think about if you're outsourcing or retendering for one of these contracts. Have a think about whether the structure of the procurement exercise is going to take this possibility into account. And when you're going through that retendering process, consult with your employees, talk to them about which part of their employment they want to do where, and whether or not that works to their detriment. Because another thing that the court found in this case is, if it's impossible for the contract to be split amongst the multiple incoming contractors, or that's going to be to the employee's detriment, then that will result in the termination of that employee's employment, and transferee will be responsible for that. So you've got to work out at an early stage whether that's going to be a possibility if you're getting involved in one of these retendering exercises where there's going to be multiple incoming contractors. So not only discuss with your employees what they would like to happen, also discuss with the transferees and work out whether or not it would be possible for them to take on employees on a part-time basis. And finally, review your contracts, make sure that there are the necessary warranties and indemnities in there to cover off any possibility that employees will be split between contractors on a part-time basis. I mean, just as a summary on this case, this is really quite difficult for people taking on contracts under duty in this situation, because there are so many unanswered questions. For example, which transferee, which incoming contractor would take on the liability for existing employment tribunal or personal injury claims? That is an unanswered question. On a practical level, how does the day-to-day work get split between the different contractors? Which day per week does each employee work? So there are loads of unanswered questions on this case. So yeah, just on that note, I'm going to now hand over to Lee, and he's going to take you through another few cases that have really impacted on employment law over the last 12 months.
Yeah, thanks, Tom. I'm going to talk to you about national minimum wage. That's rather topical today. If you've been paying attention to some of the things that aren't COVID related in the news this morning, you'll have seen the government has released its name and shame list, its annual name and shame list of companies that haven't paid national minimum wage this year. You'll probably all be sitting there comfortably thinking, well, you won't be on it. Quite amusingly, what came along with that was the government saying on its website today, along with that list, and I'm going to quote directly, was, whilst not all minimum wage underpayments are intentional, there is no excuse for underpaying workers. I think we're all agreed there. But it goes on to say clear guidance for employers on pay is available on this website. I very much doubt it is. I've looked at that website many times. I can't find a lot of clear guidance. National minimum wage should be really simple. People should not be paid below a certain amount for the amount of work they do each hour. But what constitutes them working and how you can calculate what they've been paid is remarkably complicated. And so these two cases perhaps highlight that and give us some guidance, which is useful. So the first case was Mrs. Tomlinson Blake, and she worked in a residential care home for MENCAP. Now, if you're sitting there thinking, this isn't relevant for me, I don't work in that industry, I don't have staff who sleep at care homes, then think again. There are two key points that are relevant for everyone on this call. The first one is, if you lose an employment tribunal case, and it happens from time to time, invariably someone in your business will want it appealed and will want to try and overturn that decision. I know that from experience, unfortunately. The Tomlinson-Blake case took 5 years to go from the Employment Tribunal judgment to get all the way to the Supreme Court for a judgment. So when you're faced with that call from within the business that they want to overturn the employment judgment, just bear that in mind. The second point is, and you'll hear talk of a case later on from me, the second point is that there's a case called Consul and Dunkley coming up, which has been hailed as this great result for trade unions. Well, that may or may not be the case, and I'm not sure I agree with it. But this case, Miss Tomlinson-Blake's case, was brought by Unison over 5 years at a huge cost to them, and they didn't win. This was not a good result for the unions. So one in the eye for them. The case itself, in a nutshell, as I said, Mrs. Tomlinson-Blake was a carer. She had sleep-in shifts, so she would sleep in a bed in a bedroom provided by MENCAP at the care home, and she wasn't paid national minimum wage for doing that. The claim followed, and ultimately she lost. The judgment was quite simple, and it said unless she was awake and available for work, she wasn't entitled to national minimum wage. She could be paid less. So there we go, quite straightforward in the end. The key point to take away from that, if this is relevant for you as in your industry, is that there is a difference between sleep-in shifts and being on call, and how you calculate national minimum wage for those is quite different, and needless to say, are still as complicated as ever. The other case was Mr. Augustine and Data Cars. Now, Data Cars was a taxi firm, and again, if you're sitting there thinking this isn't relevant for me, I think there are things that are most definitely relevant for you. National minimum wage, of course, should be simply that someone is paid an amount of money and you divide that by the hours that they work to calculate whether they're being paid more than national minimum wage or not. But there are things that complicate that. You make deductions in respect of certain things. So, for example, expenditure in connection with your employment, and you don't even count certain things that are paid to people. So, for example, if you had an advance on their wages, and it's those sorts of things that get employers into a pickle. And in the name and shame list this morning, the government said that 37% of the people on there, the reason they're on there, the reason those businesses are on there is because they haven't calculated properly how they should reduce the total amount of pay before they calculate whether their employees are being paid national minimum wage. And often, and they give the example, that's to do with dress codes. And that was the case here with Mr. Augustine. He was a taxi driver. If he wanted to do the higher end taxi servicing, which they called the gold service, he had to wear a uniform. He didn't have to do those drives, but if he did, he had to wear the uniform. He brought a claim to say, when you calculated my national minimum wage, because I've paid out to hire that uniform from the firm, that money should be deducted before you divide my total pay by the number of hours to see if I'm paid national minimum wage. Ultimately, the Employment Appeal Tribunal agreed, and they gave quite a broad finding in this respect. And it's a bit of a warning to employers, to all employers, about national minimum wage. His expenditure, they said, in line with the legislation, was in connection with his employment. So whether he was volunteering to do it or not was immaterial. It was this being in connection with his employment. And that's where the taxi firm and anyone else could find themselves in a bit of a pickle. Right. I did say I was going to talk about another case that was being hailed as a trade union success, which is on the next slide. And this is the case of Costello and Dunkley. Now, I don't think this was a great result for the trade unions as much as they're hailing it to be. I think this was just a case that repeats the legislation, but it provides a really excellent reminder to anyone who's got trade unions in their workforce. So what do we need to know? Well, if you've got a trade union in your workforce, you've probably got a collective agreement, and that collective agreement is going to set out for you how you determine terms and conditions of employment, most commonly pay. And you'll have a protocol, probably around pay negotiations. And that was the case here with the company Costello. Costello, as is very common, got frustrated with the pay negotiation process with their unions, and during it made an offer directly to their employees. I won't get too involved in the detail, but there was a threat in there as well that if you didn't take up the pay rise that was being offered, then you would lose out on your Christmas bonus. Unsurprisingly, the trade union were unhappy about that and started to bring claims. And the claims are for a compensation for each of the affected trade union members of £4,341 at the current rate. So it becomes quite costly quite quickly. And as I say, not surprisingly, with the legislation saying that you can't induce trade union members to arrange their pay terms outside of any organised and agreed pay negotiation protocol, it was ultimately found in favour of those trade union members and the compensation was paid to them. Things to take away from this case are, if you really want to be sure as you can be, that you're not going to get caught up in one of these claims, with your trade unions, you must be sure to try and exhaust the pay negotiation protocol you've got in place with them before you go out and make any direct offer to your employees. There's a caveat to that. The legislation is only dealing with this if your sole or main purpose is to get those trade union members to agree terms outside of the pay negotiation protocol or the collective agreement. The legislation doesn't go so far as to give you a defence, but it does talk about other purposes of offering direct pay rises, such as if you're trying to retain staff who've got special value to you as a business. And the third point to take away, if for all of you, is if you've got a collective agreement knocking around in the bottom drawer of your desk, dig it out, dust it off. It's probably in a very old style font. It was probably typed 20 or 30 years ago. Have a look at it. Is it still fit for purpose? Does it find circumstances where you can get out of the collective agreement or the pay negotiation protocol to go direct to employees if there's frustrating circumstances, or, as is common in a lot of industries at the moment, there's a shortage of staff and you need to be a bit more fleet of foot when it comes to pay rises. So take a look at that. So there you go. That's a quick summary of my cases. And I think we're looking next at immigration.
Thanks, Lee. So I think these 3 points are probably the highlight of the year. I mean, end of last year, we saw the end of free movement under the EU regs, and these were replaced by a domestic immigration system, which came into force earlier this year. Now, the EU settlement scheme was introduced for EU citizens who were resident in the UK before the 31st of December last year. The deadline to apply under the EU settlement scheme was the 30th of June this year. Since the 1st of July, EU citizens and their family members are now required to hold valid immigration status in the UK, just as any other foreign nationals would be. They can no longer rely on their EU passport or national ID card to prove their right to work. Now, we'll go on to the right to work in a minute. Next slide, please. Earlier on in the year, we also saw the introduction of a skilled worker route, which essentially replaced the Tier 2 visa scheme. Now, this was a massive win because for those that have operated under the Tier 2 visa scheme would have known that it was extremely long-winded and bureaucratic, and it meant that we had to conduct something called a resident labour market test, advertising a role in the UK for at least 28 days, and then applying for something called a restricted certificate of sponsorship. And only if we were under that quota that month would that be assigned. So we went from an immigration system where a Tier 2 visa may have taken you several months to apply for, to a skilled worker route, which has allowed us to sponsor migrants within several weeks. So it sped up the process a significant amount. Also, following on from the pre-settled and settled status digital application that EU nationals were benefiting from up until recently, the government rolled out a digital app for EU nationals and their Swiss applicants applying for entry clearance or leave to remain, eliminating the need for them to apply at visa application centres. Now, I'll talk later on about updates going forward, but this will be rolled out to all foreign nationals at some stage. We just don't know when. Also, priority services are now available for EU nationals, which means that you pay a little bit more and visa applications are dealt with within 5 working days generally. Also, it's really helpful. The Home Office have an online skills eligibility tool, which can assist employers with ascertaining whether employees are sufficiently skilled and have enough points under the new skilled worker scheme to apply for a visa. Now, this is really helpful because the scheme has opened up to a wider range of skilled employees. So it's often quite difficult to determine whether these applicants can be sponsored or not. So this is a great go-to tool for employers to check that. Also, I mean, we've all heard in the news about shortages of HGV drivers. So the government earlier on this year announced that they would allocate temporary visas to HGV drivers, pork butchers and poultry workers until the end of the year to ease supply chain shortages. Now, we could do an entire webinar on right to work, and we will do at some stage, but this is just to touch on changes. So the government have extended the remote right to work checks concession until the 5th of April next year. This means that employees can submit scanned copies of their right to work documents, and you can arrange a video call to check whether they actually belong to the employee in question. Again, adjusted right to work checks need to comply with the correct wording, so you must note on the right to work checks that they have been adjusted and undertaken on X date due to COVID-19. Workers with biometric residence permits and residence cards can use the online right to work checking service whilst doing a video call. A lot of people are now using the online checks over the manual checks, and we definitely recommend that where possible. It's not available in every visa category, but where it is possible, we should definitely be asking employees for their share codes. So that's it from my end. I'm going to hand over. Thank you.
Thank you, Shraddha. So my turn. Look, this time last year, if you were joining us, we were talking about Me Too, we were talking about Black Lives Matters, we were talking about working from home. And in some ways, all of those things have been taken on board in the last year. And various things have developed into what we're referring to as value-driven employment policies. Partially pandemic related, but partially due to what's been going on in the world generally. And that's developed through the development of equality, diversity and inclusion strategies within organizations, which often now form the cornerstone of a business strategy, not only internally, but also what they are projecting to the outside world. And that fits in very snugly with the current buzzword as well, ESG, which is what a lot of businesses are talking about. That's their environmental, social and governance, I suppose, drivers, and how they are, again, presenting themselves both internally and externally. Why is this so important? Well, it's probably quite obvious why equality and diversity is important. But as we are moving into this remote working, hybrid working world more and more, it's the inclusivity aspects which perhaps need more attention over the course of the next year, and which has been developing already, as I've said. So how do we start looking at these things? What are the things that are going to be important? Gender pay gap reporting is already there. We'll talk a little bit about that in the slides to come. Similarly, the growth of ethnicity pay gap reporting, disability pay gap reporting, all being discussed in Parliament openly, with potentially plans to introduce them in the next year or more. But it's about getting ahead of that and thinking about what you could and should be doing now, not only because it's the right thing to do, but also to sort of project to your current employees the values that your organization has, the things that actually will keep them inside, keep them with you, and attract new talent as we talk more and more about the Great Resignation. After lockdowns, people are looking more and more. We're seeing this absolutely on a daily basis as companies are challenging each other, and not only within the same sectors, but in other sectors as well, for employees, particularly at that sort of more manual, sort of junior level, but not exclusively. So thinking about sort of your equality, diversity, and inclusion strategies, looking as well at family and personal issues. So what are the policies that are applicable? We've seen the changes to contracts of employment, and providing within that contract what opportunities and what benefits you have, for example, above and beyond basic parental leave, maternity leave, shared parental leave. How do they develop into your policies? What steps are you taking to address what's probably now sort of the current issues facing us around menopause, which has sort of hit the news and the front pages of the newspapers as very high profile people take these challenges on. Looking to flexibility and evolving this sort of hybrid remote workforce, it's challenging, it's difficult, and we've had a lot of questions in already about what the announcement last night actually means for working from home, for bringing people into the office. These are things that we know you've been thinking about and have been driving things forward. Will that change? Will things develop? Well, that's yet to be seen. Looking too at diverse gender identity and gender expression, I'll be talking about one of those cases very shortly. Growing awareness around gender issues, and that's perhaps a sign of the times, a sign of perhaps the impact of social media too, as particularly younger people are collecting together and sharing their experiences. But also last year's case around Taylor and Jaguar Land Rover, and the which I think we covered last time around, just got it in there at the end of 2020, where we talk about gender neutrality, gender fluidity, non-binary expression, and how this is being dealt with within workforces, whether that's developing gender neutral policies, looking at gender neutral toilets, for example, and other things as well, which do now fit in within that, just gender gender reassignment is what the case actually brought it down on, how that will develop over the coming years. And finally, when we talk about working from home again, well-being, not only at home, but also within the workplace. How are we taking care of our staff? How are we looking after people, supporting them, whether that's in training, whether that's providing the extra holiday here or there, or giving them some sort of reward or recognition for what they've been through, as we've all been through over the past 12 months and more now. So these are just things to sort of whet appetite as we start thinking, what more can we be doing? What more should we be doing? And keep that in mind as we talk about the next few cases, which I think all spin out of these more general ideas. So looking at the next case, if we can, Dobson and North Cumbria Integrated Care. Well, it's an important case, particularly in light of the pandemic and how it's impacted on women. There's a lot of information out there, so I'm not going to go through all of it, but just to give you a brief summary of what the case was about. This is really a case that went through to the Employment Appeal Tribunal, and hearing about indirect sex discrimination, which should have taken account of the judicial notice of childcare disparity. It's a phrase that has often come up, and you might just sort of have a sort of passive awareness of, but it's really about women being less likely than men to be able to accommodate certain working patterns because of their childcare responsibilities. And Mrs. Dobbs by North Cumbria Integrated Care, NHS Foundation, which is often, you'll see as we go through some of these cases, it's often the public sector who are the ones that pursue these all the way through to a tribunal to as Lee said previously, really to protect their business and to make a point, and sometimes not always successfully. She was dismissed as a community nurse. At the time of her dismissal, the team was comprising of 9 women and 1 man. Mrs. Dobson was a mother of 3 children, unfortunately 2 of whom were disabled, and had previously made a successful flexible working request. She worked 15 hours a week over 2 fixed days, with her mother-in-law arranging her work to be able to provide the childcare cover for those days when Mrs. Dobson was working. So where did it go from here? Well, she made an application for a flexible working request. where she was asked to, after she was asked to work on occasional weekends, no more than once a month. Given she was only working perhaps 2 days a week already, it might have been seemed unreasonable in the first place to ask her to work on even occasional weekends. But she put an application in there for a flexible working arrangement, and it was rejected. It was subsequently offered back to her as a slightly different one, but she rejected that proposed change and raised a grievance. Not unusual, I'm sure you're familiar with this. And this was too rejected, as was her appeal. Now, the trust later advised that it had no option other than to ultimately dismiss Mrs. Robinson, despite offering to re-engage her on new terms. And you'll have heard over the course of this year as well a lot of conversation about the firing and rehiring arrangements, and that too might well be changed in future. This is one of those situations. They offered her a new job on those revised terms where she would have to work the occasional weekend, and she obviously said no and claimed unfair dismissal and ultimately indirect sex discrimination. The Employment Tribunal initially held that there had been no indirect sex discrimination on the basis that the provision, criterion or practice, that the PCP, applied to both men and women equally. Now, remember, as I said, that there was only one man and 9 women involved, but no evidence had been produced to put women at a particular disadvantage. So that was a test really for the tribunal, whether there was a sort of an indirect impact on women. Ultimately, the Employment Appeal Tribunal allowed the appeal, pushed the case back to the Employment Tribunal, having found that the original first-tier tribunal had erred in limiting the pool for comparison to only the team in which he worked, when the appropriate pool for comparison was actually all the community nurses within the whole trust, not just within her team. So that got pushed back, and ultimately the decision was that this was a matter which doesn't necessarily need evidence from the parties, because it's so well established that women will have more childcare responsibilities than men, and therefore would be disproportionately affected by that decision. So that's the first one. The second one, perhaps more unusually, is a first-tier tribunal case. And we don't often talk about these because they don't compel or bind future tribunals on the back of their decisions. But it's one that actually hit the headlines, hit the front pages, in fact. And if you remember, it was mainly because somebody won £185,000 in damages for loss of earnings, pension contributions, injury to feelings and interest. And this was an estate agent, worked at Manners. She made a flexible working request on return from her maternity leave, where she requested a 4-day working week, and that she would be able to leave the office at 5 o'clock in the evening to collect her children, as opposed to her usual 6 o'clock finish time. The business made a decision, and of course that decision was no, having cited that the business could not afford for her to work part-time, and therefore declining her request. They said that there would be an inability to meet customer demand and an inability to reorganize work among existing staff for that day and that 1 hour that she wanted to leave early. Now, you'll recall and you'll be fully aware of there are a set list of criteria that employers can use to reject flexible working requests. A few of those were covered off just there. But how they are justified and how employers consider those requests and indeed those rejections is absolutely essential. And what the tribunal found here was that they didn't properly consider that request. They automatically discriminated on the grounds of sex because of their failure to not consider it properly. And she was successful and went on to be compensated quite handsomely, I think, for that work that she put into it. So there's a lot to consider, and we talked again about that hybrid working, how it's likely to be around for a while, more and more flexible working requests where we are not offering them as a matter of course. This is the example here, telling you sort of directly that you need to have good reasons, and those reasons actually are likely to be reducing month after month as we have accommodated flexible working, we have accommodated hybrid working, sometimes whether as an employer, we've known about it or not, as people have managed their own working day around their client or customer demands. So looking at the next slide, which is sort of in many ways related, we're talking about caring responsibilities. And what is a carer? Well, a carer is somebody who's considered to be anyone who spends time looking after or helping a family member, a neighbor, a friend, whether that's because of ill health, age, care needs, but it's kind of regardless of those things, as long as they are identifying in that way. Now, again, statistically, quite interesting, 1 in 4 older older female workers, and only 1 in 8 older male workers have caring responsibilities. And you might have to zoom in closer than I can into that diagram there, but let's explain a little bit to you about what that shows. It's sort of age across the bottom, caring responsibilities at the side, and it shows that 3 in 5 carers in the UK are aged over 50, with 1 in 5 being aged between 50 and 69. They're informal carers, the people who have caring responsibilities but don't identify themselves as professional carers. And this is going to be a huge and increasing issue as time goes on. People are living longer. People are taking on more and more responsibilities, not only for elderly parents or relatives, but also for increasingly grandchildren or children indeed themselves. Most of the care is provided by women, and there's this societal expectation that women will still be the sort of the family carer. So carers are arguably already at a disadvantage, mainly because they're likely to be women. So this is not about sex discrimination, though. This is about associative discrimination. This is about the people who are being cared for. And in this particular case, for Mrs. Follows, she was employed on a home worker contract, but did attend the office maybe 2 or 3 days a week. Back in 2017, Nationwide, the employer, decided to reduce the number of senior leading managers, of which she was one, and make all remaining roles office-based on their account for supervision purposes. Now, I've got to remember this is pre-pandemic, when we were all sort of having no option but to work from home. So supervision was the argument, and that they said that she would need to be coming into work to be able to do that. And following a redundancy exercise, ultimately she was made redundant, possibly, and the tribunal made a decision about this, because of those caring responsibilities and being unable to attend the office as she spent time caring for her disabled mother. So this is a situation where the tribunal found that Nationwide's justifications failed to meet the established standard. What is that? We all know, I'm sure, the proportionate means of achieving a legitimate aim. That's when we're talking about indirect discrimination only. Nationwide argued that there was a need to provide effective on-site supervision and managerial support. This was considered to have within itself, as a comment, to have discriminatory elements to it, and as such could not amount to a legitimate aim. Nationwide also failed to take into account alternative non-discriminatory means of how else they might be able to achieve that aim of providing that supervision and that management support. So we're looking at, why is this relevant now? Well, we're looking at more and more ways of hybrid working, home working, remote working, whatever we want to call it. And we shouldn't be discounting, as a matter of course, sort of that management responsibility, that supervision role, if it can be legitimately and reasonably provided in an external way, in another way. And we need to be prepared to justify any new provisions, criterions, or practices that we're introducing as employers, and be prepared to justify it. So if you are thinking about developing new policies, look at what they are, look at if they are necessary, look at what they're trying to achieve, and whether, certainly consider and make notes of that consideration of other ways you might be able to get there. So the final small comment on that point is just to say that this idea of indirect associative discrimination comes essentially from European law, which has been adopted into the UK. And just because we've left the EU doesn't mean that we no longer have to follow or should be following or could follow European decisions based on areas of law which have been developed in Europe and adopted in the UK. We can move away from these things through the more senior courts, the Court of Appeal and Supreme Court. They may depend on European law, but for the moment, the tribunal certainly can have a view and can have an eye to these places. Now, my last case is one which, again, brings together a lot of these thoughts around the ESG points, the social aspects of diversity and inclusion in the workplace. And this is Mrs. Forstater, or Ms. Forstater, and CD Europe. This is one which is, again, hit the headlines this year, and will probably hit the headlines again in the coming months and years as well. This is, if you're not familiar with the claim, Maya Forstater, who works as a consultant for CGD Europe, and had her consultancy contract, not renewed after she expressed a series of gender-critical beliefs on social media. What does that mean? Well, the tribunal said that she had an absolutist approach to sex, and that she would intentionally misgender trans employees, trans individuals who she was working alongside, or indeed who she came into contact with. They said that her intention was to refer to a person by the sex she considered appropriate, even where it violates their dignity and or creates an intimidating, hostile, degrading, humiliating or offensive environment, which was not worthy of respect in a democratic society. Now, that was the first tier tribunal. And this case is all about philosophical belief. And we've seen these things before, where it's been a belief, for example, in public service broadcasting against the BBC, and vegetarian or veganism. And these have all been tested over the course of the years. And this one brings us squarely into what's being called gender critical beliefs, or the belief that a person who is born genetically a woman will always be a woman, regardless of any self-belief or protestation to the contrary. Now, this was a hugely important case because it's testing things which have really been sort of tested around the edges before, but to take it to that one step beyond. So it was heard by the President of the Employment Appeals Tribunal, and ultimately it was decided that those people who do hold and express gender critical beliefs are protected from discrimination under Section 10 of the Equality Act, and that obviously that's under the protected characteristic of religion and belief, which stretches over into philosophical belief. And the key point here, the key takeaway from this, is that final test, that test about whether it's sort of worthy of respect in a democratic society, or whether it goes beyond that. And what it said was, and again, quite strong words, that only those beliefs which are excluded from protection are those which amount to the gravest form of hate speech, whether they incite violence or indeed are akin to Nazism or totalitarianism. Now, that's a huge stretch from where we've come from before. And this is hugely important. And it means that any questions around philosophical belief, where we're testing around the boundaries and what it means to have worthy respect in a sort of the wider society, they have to be extreme views. And what we don't know yet is whether it was those views which Ms. Forstater had, which ultimately led to her being not continued in her consultancy, or not, because it's been sent back to the tribunal to find out. But why is this important now? Well, we've seen a shift. It's been front pages again. It's been in the news about trans rights, about how transgender people are dealt with, treated in the workplace and in society. Lots of talk about the Gender Recognition Act and it's being revised. Lots of talk about even trying to persuade people out of being a particular sexuality or sexual orientation. This is critical and is being discussed in society, as it's being discussed in our workplaces. And we are likely to see a clash again, as we've didn't seen before with religion and belief and LGBT rights, some sort of conflict in the workplace, which unfortunately as employers, we're going to have to manage. And we're going to have to take action to look at how to protect people from harassment whilst also protecting people who have these specific beliefs. A lot of this will be down to education. A lot of this will be about culturing that empowerment, that workplace where people feel able to be themselves, free from persecution, protected from harassment, whilst also balancing the rights of those individuals who perhaps themselves have protection for their own personal beliefs, whether that's religion or indeed the philosophical belief, as we've discovered here. Does it fall outside of banter? Does it something that we should be condoning? Is there a responsibility on us as employers to step in, on our managers to step in and reduce that? And how do we deal with it? So look, there's a lot to talk about. It's another session in itself. We don't have time for it today, so I'm going to hand over, if I may, to whoever is next. I think that's Lee.
It is. Hi, thank you very much. So I'm just going to quickly talk about, I think, what's my favourite case, which is my favourite case of the year, the case of Mr. Gellan, who brought an employment tribunal claim against a company called Allay. Now, I'll explain why it was my favourite case in a minute, but in terms of what went on, unfortunately, very common but also very straightforward. Mr. Gellan was subjected to racist comments by a colleague. There was an investigation, and the company found that had in fact happened, and so they left it at that. Mr. Gellan, however, brought an employment tribunal claim to say, I've been subjected to racist comments, and that amounts to harassment. The company took what's called the statutory defence, which is that it said it had taken all reasonable steps to stop that from happening. So they relied upon the policy it had in place, and they relied upon the training they had given to the colleague who was the abuser. That didn't wash with the employment tribunal, and nor did it wash with the employment appeal tribunal. And in fact, they were quite damning, and they gave some very, very helpful guidance to all employers, really. They referred to the fact that the equal opportunities policy, aside from mentioning harassment in the title, didn't deal with harassment anywhere else in the policy, and they were highly unimpressed with that. They also made the point that training is very unlikely to be effective unless there are long-lasting consequences in terms of the way it's dealt with, so that it's clear to people that they need to adhere to it, and also it mustn't be superficial. And the reason why this is my favourite case is because of the comment that was made in the judgment by the EAT, when they clearly showed they have a full understanding of what the real world is like outside of the court system. They said it's not sufficient merely to ask whether there's been training. Consideration has to be given to the nature of the training and the extent to which it was likely to be effective. If training involved no more than gathering employees together and saying, here's your harassment training, don't harass people, now everyone back to work, it's unlikely to be effective or to last. And it just made me laugh. I deal with a number of companies, as you can well imagine, and so often I see people thinking that they've delivered effective training, or they have in place something that's going to meet the standards that the employment tribunal demands. You probably aren't. If you're not reviewing your discrimination and equal opportunities training year in, year out, keeping on top of your policy, you are probably going to fall foul in some way. So there's a real call to action there for everyone here that's in the meeting today. On the next slide, I'm starting to look forward to the next year, to 2022, and the diversity and inclusion agenda, which I'm sure is on everyone's list of things to deal with. I'm not going to dwell on this slide. There's a really helpful checklist there to give you some guidance. And again, we'll be coming back, I'm sure, early next year to talk about that in more detail. But interestingly, on the slide after that, is talking about the duty to prevent sexual harassment. Now, this is really starting to loom in the workplace. It's got the attention of the government. And so there are things you probably need to be bearing in mind now, aside from the moral obligations you probably feel as an organisation to deal with it. And this really gathered pace, of course, after the #MeToo movement a couple of years ago. whilst not imminent, there has definitely been a call to action by the government, and the government is undertaking consultation, has published a report, and it's looking to introduce new legislation that is going to set standards on employers that requires you as an employer to take positive and proactive steps to making the workplace safer. And this ties back in with Mr. Gellin's case from a moment ago. It's not going to be enough just to have a tick box exercise anymore in respect of sexual harassment. You are going to have to take a proactive steps, and that is undoubtedly going to involve training people and adjusting your culture if you find it to be somewhat old-fashioned, as it were, shall we describe it that way. So there we go, things to think about. So I'm going to hand over now. I think that comes to you, Tom. Tom, are you there?
Tom, check your mute.
Classic.
It was always going to be someone. Thanks, Tom.
Sorry, everybody. I was in mid-flow. Okay, I was just in the middle of saying that I'm going to cover off these last couple of slides pretty brief, just because I know that time is pressing. So this particular slide looks at one of the changes that's coming forward in 2022. The government has proposed some legislation that workers should receive all their tips directly without deductions, apart from deductions for tax and national insurance. That tips should be distributed in a fair and transparent way within a specific time frame, and that employers should have written policies on how this should be done, and that workers should have the opportunity to request information about the employer's tipping record, and the government is also considering a statutory code of practice on tipping. This has taken a while. The consultation was in 2016, and Parliament is going to legislate on this when it has time to do so. It's likely that if employers ignore these rules, there will be fines in place for them, and potentially employment tribunal claims as well. So that's something to start thinking about for the coming year. Let's have a look at the next slide, please, Tom. Okay, so this talks first of all about the right to neonatal leave and pay. The government is proposing to legislate this next year as well. This would be the right for people who have babies that go into intensive care in the first 12 weeks of their life, for them to have paid time off in that situation. And it wouldn't just apply to mothers, it's also going to apply to people coming back to fathers as well, potentially. So we haven't yet seen the detail of the legislation, but this is also something to look out for next year, as is extending redundancy protection for women returning from maternity leave. This is not just going to apply to women, but also people returning from adoption leave and shared parental leave, so that they have the same rights as women who are actually on maternity leave in respect of redundancy. So it's not going to be, we don't think, an outright ban on redundancy in the 6 months after returning from maternity leave, but it is the right for people returning in that situation to be offered the first refusal of any alternative employment that is available in that situation. And again, this is a law that's going to be brought forward when parliamentary time allows. And finally, new right to carers leave. This is going to be unpaid leave, and it's going to be a day one right, so a right from your first day in employment. And it's going to be the right to take a period of up to 1 week in blocks of half a day or more, and it's going to be unpaid in respect of people's ability to care for their dependents. Finally, let's have a look at some consultations that the government has recently looked at. So These might have legislation coming out of them. The first one is the consultation published on day one, flexible working rights. So this consultation looks at 5 key areas. Firstly, bringing in the ability to make a request for flexible working on from your first day of employment. Currently, employees have to work for 6 months before they have the right to request flexible working. Second point the consultation looks at is whether the existing 8 business reasons for refusing a flexible working request remain valid, and requiring the employer to suggest alternatives to a flexible working request made by an employee, and looking at the administrative process underpinning a flexible working request, and finally the right to request temporary flexible working arrangements. So that consultation closed on the 1st of December, and we await the government's response. The second one there is the ICO call for views on updating data protection and employment practice codes that they have in place. And the final one there is looking at banning post-termination non-compete clauses. This was a consultation that closed down in February this year, and we're awaiting the government's response. Many of you, I know, will have clauses in your employment contracts that prevent your employees working for competitors or soliciting or dealing with your customers after they leave your employment. And this consultation was looking at whether to ban those, make them specifically time limited, or require employers to compensate employees for working under these restrictions. And I'm sure there'll be lots of businesses eagerly awaiting the government's response to that consultation. So I'm going to hand back now to Lee, again, just working through what to look for in 2022 in relation to diversity and inclusion.
Yeah, thank you, Tom. So I've got 4 topics here, which I'm going to try and cover off in 40 seconds. So let's give that a bash. The first one, the menopause. It's becoming prevalent in terms of people talking about it, rightly so, and addressing the issues that surround it. There was a case just last month that said that menopausal symptoms only may amount to a disability. So a physical impairment that causes substantial adverse effect for more than 12 months, which actually, if you think about it, would make sense. So please be aware of that as we go into next year. Ethnicity pay reporting is going to rumble on. I'm sure we all understand why it's important and why it needs to be addressed. The reason it's going to rumble on is because there's some debate at the moment about how you define people and how you put them into different categories. That's very easy when it comes to gender, male, female, for the purposes of pay reporting there. But when it comes to ethnicities, how do you categorize people is causing a matter of some debate. Likewise, disability pay gap reporting. Again, we all understand that disabled workers are disproportionately out of work, and when they're in work, they're paid, research says, about 15% less than other workers. And the government has asked the Health and Safety Executive to address that by putting together guidance that is to support disabled people with long-term health conditions, to keep them in work, and how to manage if they have long-term ill health absences. When that comes out, and we'll let you know, that's clearly going to set a benchmark for employers, a best practice, as it were. And finally, not a week goes by, I don't think, where I don't read an article about how artificial intelligence is inherently discriminatory and produces discriminatory results. And Bloomberg reported today that a large number of corporations are starting to use AI in terms of recruitment and placement within the workplace itself. A report from the All Parliamentary Group has just recently been published that's calling for legislation to deal with that, so that businesses are under an obligation to assess their AI to make sure it doesn't have discriminatory effects. So if you're starting to look to the future, and I'd say that's very into the future, be aware of that as well. Thanks, Tom. I think I'm coming back to you. I beg your pardon, Sharina.
Thanks, Lee. So what's on the horizon for immigration? Quite a bit, actually. As I explained earlier, there will be a digital app rollout for all nationalities applying for entry clearance as well as leave to remain in the UK, eliminating the need to attend visa application centres abroad or in the UK. That's scheduled for 2022, but as with all of these dates, they're likely to be pushed back with coronavirus and whatever else is going on. 2022 also sees an overhaul of the SMS system. I don't know how many of you operate the SMS system, but it hasn't changed for decades. The idea is that this will be integrated with an employee's visa application to provide more of a kind of streamlined application process using only the one platform. Earlier on in the year, the Chancellor in his budget outlined that there would be 2 new visa routes. Again, kind of expanding on the innovator and the startup route, so to attract highly skilled migrants, generally from tech and science backgrounds, to the UK. And going beyond, looking into 2024 to 25, there is going to be a rollout of an electronic border, making it easier to leave and enter the UK using your biometric passport. So yeah, watch your space.
Thank you, Shraddha. Now we are beyond time, so apologies. All these slides will come to you with a copy of the presentation as well. We've had a lot of questions, and unfortunately, we're not going to have time to get to a lot of them. We have been dealing with them in the chat box, so hopefully, if you did ask a question, you've got some response. There's one immediate one for Shraddha, I'm afraid, which I'm just going to sort of throw in there, which is somebody's heard that Tier 1 visas might be coming back. Is this likely to be true? Not to put you on the spot or anything, and just take off the mute.
Thanks for that, Kevin. Thanks for the reminder.
Right.
Tier 1 general type visas, where it's an accumulation of points, yes, maybe. Okay.
That was a very diplomatic answer. Thank you. And look, we've had a lot of questions about what last night's announcement means as we move into Plan B, and working from home again will be on the agenda for those people who are able to do so. I think I'm trying to be shut down as the lights go out. And if everyone wants to join in now, just to share their thoughts, perhaps on what this means and how people should be reacting. Just to pick up on one particular question, which is whether employers. Here we go. Is it up to employers to decide whether to return to working from home, or can they continue asking employees to come into the workplace as long as they have good measures in place, such as additional cleaning, wearing of masks, encouraging vaccination, social distancing, hand washing, screens? There's a long list there. Look, as far as we know, and there's some guidance we are told will follow, is back to how it was, which is if you are able to work from home, you should be working from home. There will be some exceptions. There will be people who need to come into a workplace to do their job. There may be people who need to come into the workplace for their own well-being, which is something which we've seen a lot of talk about over the last year or so. If you want to make your workplace available and accessible, my view would be that that's likely to be okay. What would not be okay, in my view, would be putting in place a 3-line whip to attend the workplace if there's no necessity to do so. And do people generally agree with that? I should gauge opinion before I give any definitive response.
Yeah, I agree with that. I think you can ask people to come in, and you could explain it's better for the way in which they work, it's more collaborative and so on. But your point is right, Kevin, that you don't have any bite, as it were. If people refuse, I think it's very difficult to discipline them, because actually they're only adhering to government guidance. And that's a very difficult place to get in, to start pushing employees to come in. If they want to come in voluntarily, so long as you've got, in terms of health and safety, reasonable steps taken to ensure safety, I think you're probably on good ground. I'm caveating all of that with this is very generic advice without knowing all the full facts, but that's my general take.
Yeah, and also I would add to that on the health and safety point, revisit your coronavirus risk assessments, because they're likely to have been done quite a while ago now, and just make sure that they are still relevant and fit for purpose.
Absolutely. And looking again at that guidance that came through for various different workplaces from the government as to what checks you should be doing, what you should be implementing for anybody that is coming into the workplace. And I just want to extend it a little bit further, and without trying not to be too controversial about it. Parties, gatherings, cheeses and wines, given that people are being told to work from home, but they can still have a Christmas party, they can still have a nativity play. I'm not sure you would necessarily have that in the office, but I think that this is real sort of a lack of leadership in many ways from the government, and it's pushing all of the responsibility to you as employers to make these decisions. Back to what Tom said, it's about doing your risk assessments not only in the workplace, but also for any events that you might be hosting, for any Christmas parties that you will be responsible for if they are organised by work, if they are for colleagues. And how much of a risk you want to take. Again, not compelling people to attend, giving them the option of not attending is going to go so far. But what happens if 1, 10, 50 people, unfortunately, catch the virus after having attended a Christmas party? Not only is it not good for them, it might affect your productivity as a business as well, and your ability to provide your services. But also it could raise a claim for under health and safety legislation, even potentially even personal injury, if you facilitated an event either to allow the virus to spread, or not taken sufficient steps to protect people from the virus spreading. So it's a real difficult balance. It's one that the government's abdicated itself from, and pushed it all onto you, I'm afraid. But do speak to us. Do get in touch if you have any questions about this. Any final words of wisdom? I can see 3 wise men, and I should perhaps refer to an angel as well. Just to wrap up. Anything else from anyone? No. All right, that's it then. Have a great festive period. We look forward to seeing you in the new year. We will be sending out invitations to many more events, developing probably some of the themes we've talked about. But first of all, thank you all of you for joining. I think this has been a record, so a nice way to end the year for us as well. So thank you, and we look forward to seeing you again soon, perhaps in real life.